Good morning and welcome to the marijuana licensing webinar. I'm Candace Bach with the Association of Washington Cities and want to welcome you to this webinar on behalf of the Liquor Control Board, MRSC, and AWC, who are all co-hosting today's event. Thanks for joining us. We want to get started. We delayed just a couple minutes while a few more of you got on the line, but we're ready to get going now. We're scheduled to go until about 11:30. We plan to have lots of time to answer questions. If you want to pose a question during the webinar today, look for your Q&A box on your screen and you'll type in your question, and then we'll do our best to get your question right off to our presenters today and let them have a chance to answer those questions. I'm going to turn it over now to Jim Doherty from the Municipal Research and Services Center to introduce our speakers today. Thank you.
Thank you, Candace, and thank you for joining us for this webinar. We're entering into the next phase of moving to a taxed and regulated marijuana market, and that's going to be the licensing phase. So we have two excellent speakers, Alan Rathbun, who is the Washington State Liquor Control Board Licensing and Regulation Director. And he'll start this off with a presentation detailing what's required of these licensees, and then also what objections cities can make to licensing. Alan has been with over 30 years experience as a regulator with the state of Washington. Our second speaker today will be John Walker. He's a deputy city attorney with the city of Tacoma. John currently advises the South Sound 911 Center, Tacoma Police Department, and city officials. He's lectured on a variety of legal topics, including marijuana, and I've attended a couple of presentations that John's made on marijuana. He's becoming one of our experts on this new field. John received his BS and MA degrees from Portland State University and his JD degree with honors in 1996 from Georgetown University Law Center. So to start off, Alan.
Well, good morning, and thanks, Candace and Jim. Really appreciate the opportunity today to utilize the services of AWC and talk a little bit more detailed relative to this pending application window on what our process is going to look like as we start receiving applications and how cities and local governments can participate in this process. So first of all, starting a week from today, the application window will become open, and this initial application window is really just people filling out what is commonly referred to as a master application through the Department of Revenue Business Licenses Services. And what that is, it is an online application which has been made available by DOR, and at this time, they are basically submitting some general information on the type of license they're going to apply for, be it a producer, processor, or retailer. If they're a producer, they have to identify whether they're a Tier 1, a Tier 2, or Tier 3, which is a variance of the size of the producers, whether they're a processor or whether they're a retailer, and basically their location and the sort of general information necessary to be able to at least start the process going. Now, this application window will remain open until December 19th at 5 p.m. And at that point, the application window will close, and we will not accept nor process any applications received after that date. Now, generally speaking, the application process includes a lot of items, and perhaps one of the most crucial items will be the verification of the 1,000-foot buffer from the sensitive areas. And I think many of you have already seen or seen what those sensitive areas are. And just to remind local governments is that burden really lies with the State Liquor Control Board to make that determination. And while the rules that were adopted by the board reference a common traveled path methodology of that measurement, that is going to be revised by emergency rule of the board. Actually, after these rules that are now adopted become effective, we will have an emergency rule which will change that measurement to a straight line measurement from perimeter to perimeter. In other words, from perimeter of the licensed premise to perimeter of the sensitive area, and that will be the determining factor. Again, one of the next things that, one of the other things that we do, obviously, is seek input from local authorities, which is a process very similar to the one we utilize in liquor applications, and that will include cities, counties, tribes if an application is received in tribal land, or port authorities if in fact an application were to come from a piece of property lying within a port authority's jurisdiction. We will verify a residency. There is a 3-month residency requirement for an applicant. All applicants, basically, they not only just the applicants, but any financiers, they have to demonstrate that they've been a resident of the state of Washington for at least 3 months prior to the date of application. We also verify that the entity, be it a corporation, LLC, be actually formed within the state of Washington. We do not, the initiative did not allow a certificate of authority, which we allow in liquor, in which you could have like a New Jersey corporation to be authorized. Here, the entity actually has to be formed in Washington. We will be performing criminal background checks, both through a personal criminal history verification form, as well as fingerprints, which will be submitted to both the Washington State Patrol and FBI. We will be conducting financial investigations. Now, the financial investigation, again, very similar to liquor, is not trying to determine whether or not someone will be successful in their operation. This is not the idea that, more money necessarily makes someone more qualified. That is not the basis of our evaluation. Our evaluation is basically twofold. One is to determine that we actually have identified exactly what we classify are the parties of interest on an application. In other words, who can or will exercise control, and to make sure that those people are investigated and identified on the license itself. And then secondly, to determine to the best of our ability, the ability that the money that is being utilized to start and operate this business is not illicitly gained in any way. We will then be looking, in large part, a big element of our evaluation is there's a requirement that each applicant submit an operating plan. And this operating plan, especially in the producer and processor end, really is a detailed summary of what their premise looks like, what they're going to do, how big their grow is, something that demonstrates that they understand the rules and regulations relating to each one of the license types. And then finally, before we issue any licenses, there will be a final inspection of the premise. It will be a determination that all their infrastructure is in place, be it security cameras, their traceability system is in place and operates and connects to the Liquor Control Board system. And it is not something that's going to be just a paper process. We will be investigating, in fact, the premise itself and make sure that they're meeting the requirements before we will issue a license. Now, as we do in liquor, once we get the application and it's assigned to an investigator, and one of the first things we do is have a phone interview with the applicants and verify the information they've submitted online, but also make sure it's clear who the people are that are invested in this particular license. At that point, once we get that information, we will be making notification to cities and counties, governmental jurisdictions, and asking and sending them a notice very similar to that we send for liquor, in which the local authority has 20 days to respond with an approval or an objection. Local authorities do have the ability to request an extension. We ask that that extension be in writing. It could be email. It could be in written form, through the mail. But we will accept a request for extensions, as long as those requests for extensions aren't, continually submitted without some justification. I think we have routinely in liquor provided the first extension without much hesitance, but beyond that, we're going to need to know why it's taking so long to make that determination. Again, a failure to respond within that 20-day period is viewed by the Liquor Control Board as approval. Now, what we're going to be starting with when we get these applications in is we're going to be concentrating our efforts on the producer or growers and the processors. The retailers, the notification of local authorities on retailers will await a lottery, if in fact a lottery is necessary. What we were not expecting local authorities to do is make comment on a location that may in fact not be legitimate or not even be eligible for consideration by Liquor Control Board. So to start out with, what local authorities can anticipate is notification of producer and processor applications within their jurisdiction. Again, as in liquor, a local authority can object, and the objections can either be to the location or to the application or the applicant, be it the person or the entity. The Liquor Control Board has said from the very beginning that we are not going to base a potential denial strictly on local land use ordinance or a moratorium. These are issues which any denial we have to adjudicate, and we are not going to adjudicate based on local ordinance. However, if a local authority were to advise us in their documentation that there is an ordinance that might be a restriction based on where a person wishes to cite their license location, we will advise, and we advise the applicant of all local authority objections and encourage them to work with local authorities where they can to try and overcome those objections. But I just want to be clear that we're not going to be basing a potential denial based solely on a local ordinance. The statute does give substantial weight to objections which are based on chronic illegal activity, and chronic illegal activity is defined in the statute. Now, this is a definition that's actually pulled verbatim from liquor statutes, and while it's probably not going to be real relevant to the beginning of this new marketplace, it certainly is something that may become more relevant when we look at objections to renewals or subsequent as people move around in this industry. But it is the one element in which the statute requires Liquor Control Board to give substantial weight to an objection from a local authority. And if a license is to be issued by the Liquor Control Board over a local authority objection, the board at its discretion may grant the city an administrative hearing. And again, may is a crucial word here. If an applicant is denied, the board must provide an adjudicative hearing to the applicant, but the board has discretion in offering an adjudicative hearing to a city or county that may object to a license application. Again, as I said, one of the elements that's really crucial if a local authority is going to seek denial is to support that allegation. And I call your attention to a specific Washington Administrative Code, which is 314-55-050. That contains basically 16 elements under which the basis that the Liquor Board may deny an application, may or suspend or cancel a license once it's issued. So if a local authority seriously thinks they have a concern relative to a location or an application, then I think it's going to be incumbent upon the local authority to have that objection based on what one of these 16 grounds are. And so I think you or legal counsel within your jurisdiction should take a look at what those are. Again, if the Liquor Board chooses to seek denial of an application, and even if that denial is based on the fact that this location is maybe within 500 feet of a public school, we still must, under the provisions of the Administrative Procedures Act, offer that person the opportunity for an administrative hearing. Nothing is automatic. The applicant is always given that right to an administrative hearing if they so choose. Now, the administrative hearing is traditionally held before an administrative law judge working for the Office of Administrative Hearings. That administrative law judge issues an initial order following the administrative hearing. That initial order is then reviewed, and the board will issue the final order, which may or may not be the same as that initial order that was drafted by the ALJ. And again, all actions by the board are appealable in Superior Court. Now, as I said before, very much like the liquor process, when it comes to license renewal, and again, marijuana licenses will renew on an annual basis. Approximately 90 days prior to the renewal, the local authority, city or county, will get a listing of all the pending renewals within their jurisdiction in that 90-day period. And then the local authority again has an opportunity to submit an objection to that renewal. And again, I reference back to that WAC that we just discussed. What are the grounds? You know, is there a demonstration? Has this been a nuisance? Has this been an area in which there's been criminal activity? Has local police seen issues there that we should take into consideration in considering a renewal? As with any notification, the time frame for submitting that objection is crucial. The objection must be submitted at least 30 days prior to that license expiration. Otherwise, that objection just will not be considered. So, as in all the notifications, the time frame is crucial. Again, it's a very similar process to objecting to an initial application. The one thing that is different about marijuana than it is for liquor, the board has made provisions that we will be conducting random criminal history checks and random fingerprints of existing licensees upon renewal, which is not something we're doing in liquor, but we are going to be doing it in marijuana. And this is just to let you know the board is taking this opportunity to do that in addition to assure public safety. As I said before, the retail licenses are going to be treated a little bit differently. The Liquor Board has established that statewide there will be 334 locations for retail licenses to sell marijuana. The allocation of those down to the city or at-large county locations is posted on our website. And if we receive more applications than allotted in that jurisdiction, we will be conducting a lottery that will be performed after a pre-screening of those applicants. And then subsequent to that lottery, we will go through the rest of the process where the LAs will be notified and we'll do the remainder of the screening necessary to determine whether someone's qualified to hold a license. Now, what's going to be entailed in that pre-screening? One, it will be a verification of a 1,000-foot separation from those sensitive areas. Two, we will do criminal background. We will verify residency and creation of if the entity is legally created in accordance with the initiative. We will verify the applicant age, which must be 21, and we will verify that the location is under consideration. It's a serious consideration between a potential applicant and either a property owner or potential landlord. One of the criticisms that came of late that played into the media was a concern that people are going to try and game the system, either from an applicant standpoint or from a landlord standpoint, and that they're simply going to submit an application that they know meets the 1,000 feet. Well, we're not going to allow that. One, we'll be making a physical visit to the site, so it's not going to be a Burger King. It's not going to be something that isn't a legitimate site, and we're also going to have verification that there actually is a conversation happening right now. What we aren't requiring is that the property be purchased or that there be a signed lease before we submit the application. We felt that was an unreasonable restriction to put on someone just to get into a lottery. But we will want to verify that this is a legitimate location, that a landlord hasn't got 4 applicants for one particular location. If they're going to have interest, they're going to have to demonstrate that they've got 1 applicant for that location that's acceptable. So we are going to go through that as well. But this is, again, what we will be doing as a pre-screening before we conduct a lottery in a given jurisdiction. Now, the actual protocols for the lottery itself are still under development. The lottery will be witnessed by an independent third party, but we want to be able to go through all the scenarios as we possibly can, and we'll be posting those protocols before the close of the application window as to exactly how it's going to work. As I said before, after the lottery is conducted, we will continue with the application process, which includes the local authority notification and the remaining application process as it goes forward. And certainly I want to make myself available and ourselves, all three of us, available for any questions you might have. But again, we're continually trying to post updated information, including frequently asked questions and fact sheets, and all the timelines will be available on our website. And if you haven't already done so, I encourage you to join our listserv. We have quite a few. It's been a very popular website to this point, but I think that's the best way to stay engaged. So with that, I'll go ahead and turn it over to John. Unless you want to, do you want to field questions now, or do you want to wait?
We have a couple of questions
Sure.
Right now that are pretty specific, so maybe we'll do a couple of these now, and then we will go to John. So the first question was, with the 1,000-foot rule, does a building or structure need to be there, or can owning the property cover the rule?
It really doesn't require the building be in place. It really is intended to be, perimeter of the facility to the perimeter of the sensitive area. So the building doesn't necessarily have to be in place. If someone wishes to, buy the property and then start construction that long, yeah, it's not prohibition to have a building in place.
Okay. See, will the Liquor Control Board share the background check information with the local authorities, and can local authorities assist in pulling together the background check information?
I think that, certainly we can, I suppose, request it. It isn't a routine practice for us. I think there are certain things that we can release, certainly conviction data we can release. We cannot release arrest data. That's not disclosable, and the FBI and State Patrol is pretty sensitive about that sort of information. I think we are certainly looking for any information that if local authority has knowledge of something that we may or may not know, we certainly encourage. That's one of the reasons that we would like to have that partnership. Like I said, we can release. It's not something we routinely do. And like I said, conviction data is readily available, but arrest data, which we also request, would not be disclosable. Okay.
One last question before we go to John. And just to remind the folks on the webinar, please be typing in your questions as we go, and we will find opportunities to ask those questions. Does the Liquor Control Board have GIS type maps to show the 1,000-foot buffer? And if so, can you share them?
Well, we have developed the GIS system. I think the GIS technology is a good technology, and we wanted to make use of it. But it's not the technology that's the challenge. The challenge is the data sets. Some of the data sets I think we have available, and I think we probably can share. It's just that I think the biggest thing for us to say about our GIS system is our GIS system will likely be able to tell us no, but it won't be able to tell us yes, because there are certain data sets which are just not well documented, like transit centers, like arcades, like recreation centers. There's simply not a data set like there is for daycares, which we're saying daycares have to be licensed by the Department of Early Learning. And so we have a data set. We have a data set for schools. So I think we can share information, and we can do that through the Liquor Control Board and through agreements if necessary. But we're going to be making physical visits to the site itself. Instead, the GIS system will help us say no, but it won't allow us to say yes, simply because not all the data is readily discernible on our GIS.
One last question on the 1,000-foot rule before we turn it over to John. Are trails considered parks, and do they fall under the 1,000-foot rule?
Trails are specifically excluded from park definition according to the rules.
Thank you.
announcements. Okay, so we're on the right PowerPoint this time. And most of my comments are really going to be directed based on my experience responding to liquor license applications, because we don't have any experience responding to marijuana license applications. So, but we can draw a lot of conclusions about how we should proceed as cities based on what happened with liquor licenses. This may seem very obvious, is that you want to have a good relationship with the Liquor Control Board and their folks. But this is really a big key. In my experience, if you have a point person who has a good relationship with the local enforcement officer, with the licensing folks, then excuse me, then you're going to have a lot more success with reaching the goals you want to reach, and with understanding what the liquor board can and can't do. This is the other key thing for cities is how are you going to route this when you receive it? The application is going to come to your chief executive officer, but except in maybe the smallest jurisdictions, the mayor, the city manager is not going to be really interested in screening these. It's going to go to somebody, maybe a detective in the police department or somebody in the planning division, and you need to decide on that person and make sure it's somebody who is going to be familiar with the regulations and familiar with how you should respond to this. And then you also need to decide how are you going to route this. It's really important to make sure that the right people get their eyes on the application. And I've identified police, planning, building, and fire as at least 4 that I would think would want to take a look at it because they all fulfill different roles and are going to have different sorts of information that they can add to the process. And you'll see fire there, and that may seem a little unusual to see that, but just remember all the authority that the fire marshal has. And it may be a building that, particularly if it's a grow, you're definitely going to want the fire department involved. And for retail establishments too, just to be sure that they have the proper exits and that they don't have any fire hazards, because that is one, the fire marshal does have kind of the authority on the local level that if there are violations, they can shut people down. And so you really want to know about that ahead of time, and you want to be able to advise people ahead of time. And the other thing to decide in advance on your routing is who's going to make the final decision. Are you going to object? Are you not going to object? You know, I know cities across the state are taking very different approaches to this, and you're going to want to make sure you have that person identified who is going to be able to make a decision that's consistent with the policymakers at your city. Alan has already talked about some of the mechanics of the objections, the 20 days to respond, the fact that you can ask for an extension. And just be sure if you're making an objection or asking for an extension that it's in writing. And if you object, you have to have a statement of all the facts on which your objection is based. And I'll talk a little bit more about that in a minute. But it's very important to make a comprehensive objection. Something short and sweet probably isn't going to get you very far. And Alan also pointed out that if the council can, your council can ask for a hearing with the liquor board, but I am not aware, maybe that's happened in the past. That would be sort of an unusual situation, but this is marijuana is an unusual situation for all of us. And here you can object, and really you can object for any reason they shouldn't get the license, with some caveats. And the biggest caveat is you want to maintain your credibility with the liquor board folks. If they think of your city or town as, you know, that city or town that always objects to everything on any basis, then when you really have an objection, it's not going to have much, carry much weight with them. They're going to be skeptical of it. If on the other hand, you're somebody, they know that, oh, well, when this city objects, we know they're going to give us a package. They have very good reasons for doing this, that's important as well. And the real reasons you want to object are in WAC 314-55050, and I'm not going to go through those. You probably want to familiarize yourself with those. And with many of those, the liquor board is going to be looking at these issues, but what the city can do is can be a sort of backstop. The liquor board may not get perfect information. You may have somebody at the police department who knows something about that applicant that isn't going to show up on a III. And, or the planning department may know something about that particular building or what have you. And their reasons also, you may want to object for not because you're sure your objection is going to carry the day, but to sort of identify someone you think is going to be a problem and notify both the liquor board and that applicant that this looks like there's going to be a problem. And you may be able to even, something we've done in the past in objecting is gotten an applicant to change their ownership structure. And you may think, well, it's, they've got a straw owner, and there's only so much you can do about that, but you can let them know that you're watching and that, if they do have something you suspect is straw ownership, they're going to behave themselves a lot better if you've sort of identified that for the applicant. The objection we've used in the past that has been successful is the chronic illegal activity objection, because the liquor board has to give substantial weight to that. And I'll talk about that in a moment. I see I did mention citizen complaints at the bottom there, and that's something you're going to have to decide how to handle, what kind of approach you want to take based on citizen complaints. You may just have people who don't want a marijuana business in their neighborhood, and that may be something you just can't do for them. As we get past the initial application stage and we get into renewals, that may take a much bigger role. And I put over service there because that is, as Alan noted, the WAC is verbatim out of the liquor board regulations, and we may see some sort of over service regulation later on, but it may be something that, you've got a retailer who doesn't sell just the limits. They're selling way over the limits, and you have people who have brought you that information, and you want to share that with the liquor board, obviously, but if they're a repeat violator, that's maybe down the road a reason to say they shouldn't get their license renewed. So the chronic illegal activity is a pervasive pattern of activity that threatens public safety. And it can also be based on things that their patrons do and things they've done in the past at other licensed facilities, and I believe it also including other licensed liquor facilities. And you want to be sure you can document this. What about, if this comes straight out of the WAC, the crime statistics, police reports, emergency medical response data, calls for service, and things like that. So your police officers aren't going to remember every little call, but if you have police reports and things like that, that's going to help them remember. So I said, my remarks are really based on the whole nightclub scene, because that's who we object to. That's who we have had problems with in the liquor scheme. And so when we talked about chronic illegal activity, we were talking about fights, big crowd problems, lots of DUIs. And our goal was to show that public safety resources, police and fire, were being diverted to this location. This location was using up a huge amount of public safety resources to the detriment of the rest of the jurisdiction. And so it remains to be seen how these marijuana businesses, if the chronic illegal activity objection is really going to be something that local jurisdictions can use or not use. And of course, if you link it to marijuana use or sales, it's going to be more likely to result in a denial or non-renewal. So when you make an objection, be sure that it is compelling for the liquor board. Draft declarations for your people with knowledge include the police reports, the computer-aided dispatches, any documents you have, and give them the legal arguments. You should have your attorney draft this up, and you should put it into an easy-to-understand package so the liquor board isn't, they aren't scratching their head wondering what your objection is all about. And if you want an example of one that has been successful, give me a call or send me an email, and I'll send you one where we did manage to have somebody non-renewed, and it was a very good thing for our jurisdiction. So if you do end up getting a denial or non-renewal, just remember that the applicant or licensee may request a hearing, and so that's why you want to already know ahead of time, do you have a strong case? And if you're going to object to a renewal, be sure you do it 30 days ahead of time. Otherwise, you're going to waive that objection. There's also such a thing as an emergency suspension. Don't expect to get this. We asked for one at a location with the triple shooting, and we didn't get it. So there may be a situation where you need to do that. Just remember, it's hard to get. So as you approach this, be sure to have your procedures in place. This is coming up very quickly. Know who's going to make the decision, and maintain your relationship with the Liquor Control Board and maintain your credibility with them. And really, one of the big things to keep in mind here is that the Liquor Board has their role to play. And you can look at the WAC and see what their decision-making process is and what their standards are going to be. And you may wish that they're going to deny somebody a license because they're putting it in the wrong zone and you've said they can't put it in that zone, but that is not going to happen. So just like with many other areas, you need to be sure that locally you have the tools in place to use to regulate these operations at your local level. And that can entail zoning, it can entail licensing, it can entail nuisance. But think about what you don't want to happen with these marijuana businesses and tailor your local regulations accordingly. Because it's really up to you to take care of your citizens and to carry out your policymakers' wishes in regard to marijuana businesses. The Liquor Board will certainly work hand in hand with you if you have a good relationship, but they have their role to play and we all have our role to play, and we need to respect that. So, turn it over to Jim.
I have just a couple of comments. John works for a city, and a lot of his comments were directed towards cities, but certainly for local authority, this applies equally to counties. So when you're referring to police, obviously for a county, the law enforcement authority is the sheriff's office, so keep that in mind. And one other thing that came up as he was talking, he pointed out in his slide about who makes the decision. Cities need to be careful to talk that out. Because the notice is going to go to the mayor or the city manager, and theoretically they could give the response on behalf of the city, but it should be talked out with the city council so that they know whether or not the city council is going to be consulted on this or whether the council is actually going to be making a decision. And that may vary depending upon whether it's a large jurisdiction or a small jurisdiction. Frequently in smaller jurisdictions, it would be very normal for the council to get involved directly on all issues of this sort. So I think we're going to open it up to questions. John and Alan, if you want to step up this way, maybe we can
sure, just all
direct questions and individually step in front of the camera when you're going to be responding.
Great. So we have certainly a few questions and more coming in. First off, will an extension for the license be granted to coincide with the length of a city's moratorium? I think what they're asking is if a licensee received a license from the state and the city has a moratorium in place, would there be an extension granted to match that period of time?
Yeah, our license, the issuance of licenses will really not be respective of any local ordinance. So we really won't extend or not extend, a license. What we do have in a rule is a comment that says that the issuance of a license by the Liquor Control Board does not guarantee your ability to operate, that you still must be in compliance with any, applicable laws, local or otherwise. So it really, we aren't trying to align it with any local ordinance. It is simply going to be a separate issue that the applicant or licensee will have to deal with.
Okay. The 20 days to respond, is that 20 calendar days or 20 business days?
It's 20 calendar days. And basically the notices that come out typically, give a date for response. So it's pretty clear to people. So.
And again, another question about the 1,000-foot buffer. There's always a lot of questions about the 1,000-foot buffer. How is it measured, parcel to parcel or building to building?
It is measured perimeter to perimeter. As I said, the GIS tool that we have developed will be helpful in making a determination of, no, it does not appear to be eligible if in fact there's a school that's clearly within that area. The challenge we're going to have is much more of some somewhat obscure databases. And we will be making field measurements, and 1,000 feet will be a challenge, especially a straight line measurement in a downtown area. We very likely will be utilizing handheld GPS units and calculating the distance as the straight line between the perimeters.
Will there be any more involvement from a local authority expected other than commenting during the 20-day window?
There's nothing in statute that talks about anything else. I mean, obviously what the Liquor Board hopes is that there is consultation going on with the applicant, so that the applicant is certainly aware of what the local regulations might be and how they might be involved. I mean, obviously our enforcement officers, as John mentioned, want to continue to have a good relationship with local law enforcement as well. But relative to the particular application, it's really the ability to submit an objection. If they have questions, the investigator is normally referenced on their notice, and they can certainly call and ask a question, but we're not asking for anything further.
You mentioned in your presentation that a city not commenting would be considered approval. I put quotes around the term approval. I think you had quotes around it in your presentation. Is that really what the Liquor Control Board considers it? Is it approval, or is silence approval?
It's basically silence is approval is the way we've looked at it. It's not an objection. So therefore, whether or not it's approval is perhaps a use of a term internally that we use, but it really just means there is no comment, and so therefore, without an objection, we're just going forward like there is no objection, and so therefore, it isn't necessarily marking the X box approval, but we're certainly not going to consider it as a problem for local jurisdiction.
Okay, thank you. See a few more questions here. Is the Liquor Control Board considering giving preferential treatment to PDAs formed by municipalities to operate retail locations?
And help me with PDA, that's a public development authority. Right now, we aren't giving special treatment to anyone. We've actually the more normal question that I've been asked over time is whether or not we're going to give preferential treatment to someone who already has an operation in medical marijuana. And no, the whole licensure process is based on being able to meet the minimum qualifications in rule and statute. And if you meet those qualifications, then you're treated identically to anyone else.
So next question, potential applicants may be reluctant to apply in a jurisdiction that has a moratorium. How will the Liquor Control Board accommodate these applicants that want to apply during the 30-day window, but the city has a moratorium in place?
I'm not sure that we can accommodate it. I think what our message has been that if in fact they apply within a jurisdiction that has a moratorium, we'll acknowledge that. We'll continue to process the application. I think the decisions that have to be made by the applicant is going to be around, before they can get a license, they're going to have their infrastructure in place. And the decisions will be, from an applicant standpoint, how much investment do they want to make unless they have some certainty to that individual location.
Can the Liquor Control Board provide a link or information for the Washington Department of Early Learning Licensed Childcare GIS data?
We have an agreement with the I think it's now signed with the Department of Early Learning. However, they are extremely sensitive about the sharing of that data, and we have to respect our agreement. My suggestion is if the local jurisdiction wants that information, that they contact the Department of Early Learning themselves, because we have promised, because of their safety concerns that they have over their database, that we not disclose that information.
I think we have a couple more questions coming. In the Liquor Control Board's distribution of retail sites, you've got at-large sites. How will those be located? Can cities that have no retail designations currently end up with one of these at-large sites?
Yes, the concept for the at-large site is that if the location is to be either in the unincorporated county or within an incorporated city which was not allocated the store according to that allocation that was posted on our website. So it could be either.
With the notice that will be sent to cities for an applicant has applied for a location in their city, what information comes with that notice?
Generally,
address, phone number, social security number?
Generally, it will be an address. It will be names of individuals. It will be the name of the entity itself, the trade name typically, and location, including address. So as I recall, that's about the limits on the information. It's the people, it's the entity itself, and the location, and the type of license that they're applying for, be it a producer, processor, or retailer.
When will the Liquor Control Board actually issue permits, licenses?
That's a good question. I think that one of the things that a large part of the application process is as dependent upon the applicant fulfilling their requirements as it is on our processing time. We certainly anticipate producer and processors aren't going to be issued for certainly for I think we're guessing at least 90 days before we're going to be ready. But like I said, in large part, before we can issue a license, they must have their infrastructure in place. They must have the ability to have an inspection that demonstrates that their floor plan is as they propose, that they have their cameras in place, that they have their security, that they have a traceability model, which is a software that can feed our software that does the seed to sale. And they must have all that requirements in place before we can issue a license.
No, I'll just ask this one. So this has to do with the medical marijuana industry. Will the Liquor Control Board, what will they do with an application of an existing medical marijuana place that is now applying to be a retail location? Do they need to operate their medical marijuana business as they would need to operate a retail business, or are there any parameters that you look at differently?
Well, again, it might depend a little bit on the type of application that's coming. There's not a prohibition nor any special treatment given to someone who might be operating, and I hesitate to what term to use, a medical marijuana business. First of all, just understand that if you're a producer or a grower, at the time of our final inspection, you can't have any plants in your facility. So it's not like you can just flip a switch and be a medical marijuana grow operation one day and be a recreational grow operation the next day. You must have a facility that doesn't have plants. It's actually after we issue a license that the producer is granted 15 days to bring in non-flowering plants. And we don't ask where they come from. but they have 15 days to bring in non-flowering plants at that point. So if it isn't so much as flipping a switch. If it's a person that is, has a community garden and has this sort of facility in which patients come in right now, obviously a medical marijuana facility would have to meet all our requirements to be able to obtain a retail processor or producer license. And recognition of what they were doing in the past really isn't that relevant.
Can an applicant be more than one type, producer, processor, and or retailer?
An applicant, there's some similarity to liquor here in the sense of what we call tied house. A single entity or person cannot have interest in both what we call non-retail, which is a producer and processor, and a retail. In other words, if you have any interest in any producer or processor facility, you can't have an interest in a retail facility. There's also a limit as to the number of licenses any person or entity can have interest in. Each one of them is 3. So you could potentially own or be a part of owning 3 producer facilities statewide, 3 processing facilities statewide. Or on the other hand, you could own up to 3 retail facilities statewide, but the retail facilities could be no more than 33% of the locations within any jurisdiction if there's multiple. In other words, if you've got 4 locations for a given city, you could have no more than 1 location by a single ownership or entity within that city.
Back to the 1,000-foot rule. The term perimeter is still not being defined. When referring to a straight line measurement, is it a straight line from where? From building to building, property to property line?
It would be property line to property line from, again, the closest straight line distance between the 2 property lines, be they, from a location, a property line surrounding a business entity being the licensed location to the property line of a park.
Will a notice be sent to the city if the Liquor Control Board determines that the application is for a location within a 1,000-foot buffer?
That's really not, our notification is actually going to be prior to us doing that measurement. So again, the burden will fall upon us to determine whether it meets a 1,000-foot buffer. The only thing that we will know on the retail side is that at the time we notify local authorities, we'll probably have done the pre-screening on the retail side. But in the other ones, we're not going to be notifying them the 1,000-foot buffer. It's basically going to be giving them a location. If the city knows that there's some entity there that's within 1,000 feet, we'd love to know. In other words, they know that there's an arcade that's within that 1,000 feet, we'd welcome that opportunity, because at that point, for a producer or processor, we have not yet conducted the 1,000-foot measurement likely.
Will the Liquor Control Board notify the city if they've determined to grant a license?
Yes, the city is given a notice of basically an approval letter, which states that a license has been issued for a particular location.
Is there a waiting list if an application comes in after December 18th?
We have not determined any potential waiting list. My understanding is that if something comes in after that time, they'll simply be notified that they failed to meet the 30-day window, and it will simply be turned back. There's not a waiting list. Now, there is the potential, obviously, at some date in the future for that application window to be opened again, but right now, no waiting list has been determined.
What are the limits regarding the number of production and processing licenses per jurisdiction?
There are no limits on the number of producers or processors, either by jurisdiction or statewide. The one limit that has been placed on production is an overall state limit of 2 million square feet of production area called plant canopy. That is one thing that is limited. If we get more qualified candidates that have a total square footage area of over 2 million square feet, then basically every producer will be proportionally downgraded to meet that maximum level that we have for production. Again, it's just square footage. There's no limit on the number of licensees.
Back to the 1,000-foot buffer, how should a city address, or maybe how will the Liquor Control Board address the 1,000-foot buffer in regards to an urban growth boundary? I'm guessing the question is something along the lines of, it's not an incorporated part of your city yet, it's part of the urban growth boundary, and there's a sensitive location within that area.
Yeah, this is an area which I should probably be looking to Jim to respond to. This is an area of specialty that I'm not that familiar with. But
I'll take a crack at this, John. You can chime in if you want. The urban growth boundary is an area that the city does not yet have official jurisdiction over. It may have an agreement with the county for some of the zoning provisions, but I would think the city would comment for things within the actual city limits, and it would be the county that would provide input for things that are outside of city limits in that urban growth area. Now, obviously, a city and a county can coordinate. If a city has concerns for something in the urban growth area, they should communicate that to the county. Is that the way you think that, John?
Yeah, that's how I would approach it.
Okay, thanks.
Yeah, I've heard urban growth area boundary discussions before in liquor and actually in alcohol impact areas, but not had to answer a question, so thank you.
Next question, when does the applicant pay the $1,000 fee? Is the $250 fee refundable?
Okay. The initial application fee is not refundable. Neither is the fee that they pay to BLS, nor any fees that they pay for the Secretary of State's office to register their business entity. Those are all non-refundable fees. Once it is determined that a license will be issued, we will send a notice to the applicant that the amount of dollars they owe to their next renewal. What we do as part of a member of basically the UBI business identifier group, we align the renewal of or the expiration of their marijuana license with the expiration since of their LLC. So at that time, it's only at the time of issuance that we will send a billing to get the amount of license fee subject to whenever their business entity will expire.
Will the Liquor Control Board revoke a license if the location violates a city ordinance and the business is not able to open?
I don't think we will. We would have no grounds to revoke based on a local ordinance. I think what would likely happen is that will be an issue that would have to be dealt with between the applicant or license holder and local jurisdiction, because we wouldn't have grounds to revoke or cancel a license based on their inability to open at a local level.
Okay. Does having infrastructure in place mean that would include a business license, a local business license?
No, what we're really talking about is what are our requirements. So it would be whatever our requirements in rule or statute would be. Like I said, you have security, you have those sorts of things, but it wouldn't necessarily mean any sort of approval from the local jurisdiction.
Will the approved plant canopy total square foot be available? Is that available on your website someplace, what the total square foot of plant canopy is?
You're talking about what the statewide?
Yes, I believe so.
We haven't talked about it yet. I think that there will be some interest in what that total will be. I'm sure, in fact, the media will probably be asking us that. But just so you understand that figure probably won't be gathered until sometime downstream, because they won't provide us with a detailed square footage until we actually ask for their operating plan. And so I would assume that it will be available downstream. I don't see any reason that we wouldn't provide it if someone wanted to know it.
Great. That actually, believe it or not, exhausts the questions that we've received from our webinar audience today. So Before we wrap up, maybe I give Jim, Alan, and John all an opportunity for any final closing comments or thoughts.
Thank you. This is Jim again from Municipal Research. As always, if you have questions on these issues, you can send questions to MRSC by email or give us a call. If we don't know the answer offhand, we'll certainly research it and contact Alan. It's an issue where we need some guidance from the Liquor Control Board. But keep the questions coming. We certainly have been getting a lot. That is by far the biggest issue that we've been dealing with at Municipal Research. We're having more hits on our web pages on marijuana issues than any other topic, and we're seeing a growing number of questions as we're getting closer to licenses being issued. So keep us in business, keep the questions coming.
Again, I want to thank AWC as always. We've had a great opportunity to participate in many forums, with your members, and we certainly appreciate it. Again, look at our website. There certainly will be contact information in which you can reach me or anyone else in our licensing team to ask specific questions. We want to be available to help local jurisdictions as much as we can during our process. It's not many chances that you get to start a brand new industry. We've talked an awful lot that the rules that we have in place are not going to be the final rules. There are going to be more rules coming as we develop more information and more questions are asked. We just really appreciate the cooperation of AWC, and we view you as partners in this process. And if you have any questions, we'll try our very best to answer them.
I just would close with pointing out that local jurisdictions have their tools, and some of the questions about would the liquor board revoke based on the lack of a business license, that just highlights that you have the authority to do things like shut down people who don't have business licenses. The liquor board is going to go through their licensing process, and you want to work with them, but you want to always remember that all your local rules and laws apply to these folks as well. And they can't operate without a business license, and they can't operate in the wrong zone, and they can't create a nuisance. And so those tools are still available.
Thank you very much for joining us today.